May I proceed, Your Honor?
You may.
Chief Justice Rowe, Honorable Justices, and may it please the Court. My name is Sophia Masnikoff, and along with my co-counsel, Olivia Robbins, today we represent the respondent in this case, the state of Florida. Of the two issues before this Court, I will address the first issue, that the application of Florida Statute Section 836.15 did not violate petitioner's constitutional rights to free speech. There are three reasons this Court should affirm the judgment of the 7th District Court of Appeal. First, Florida Statute Section 836.15 does not survive strict scrutiny. Second, petitioner's actions fulfilled all elements of the statute. And finally, the application of the statute did not violate the First Amendment protections of free speech.
Since you're arguing a strict scrutiny analysis, do you concede that this is a content-based regulation?
Yes, Justice Wright, absolutely. This statute is a content-based speech restriction, and based on the decision and based on the court in Miles v. City of Edgewater Police Department, the court stated that content-based speech restrictions will not survive strict scrutiny unless the government can show that the regulation promotes a compelling government interest and that it chooses the least restrictive means to do so. In this case today, the government interest of protecting individuals from online bullying was compelling because students should be free from psychological distress in schools.
Well, let's talk about psychological distress. Is there an objectively reasonable standard here? Because what might offend you may not offend your co-counsel.
Yes, Your Honor. A student can use their reasonable person standard to see what psychological distress would be caused to them, and in this case, it is the legislature decided that regulating cyberbullying was a prominent issue, and therefore, because of the psychological distress that can cause self-harm in students and many other psychological issues in students, and therefore that's a prominent issue that they needed to regulate in this case.
And certainly I understand the legislative intent there, but is it reasonable for an athletic team to have psychological harm when someone says they're terrible? I mean, don't people say that all the time about sports teams when they lose?
Yes, Your Honor. However, in this case, when students say that about other students, it causes psychological distress, and they're not just talking about the sports teams, they're inflicting harm on the students themselves.
But the facts of this case were more of a broad sweep type statement,
yes,
correct?
Your Honor.
That the school sucks or what have you, the team sucks. It wasn't personal to any particular.
Yes, Your Honor. However, they still felt public humiliation in this case because the post was shown to CBA's followers, which included their peers at their high school and also members of other basketball teams that they compete against in their county. And
doesn't a team face public humiliation when they lose?
Yes, Your Honor. However, this CBA's actions of posting this go further than that and propose psychological distress and public humiliation on these students that is unnecessary and is not constitutional. Further, the statute is narrowly tailored to achieve that interest of protecting individuals from cyberbullying because the language in the statute is clearly focused on protecting students from bullying and psychological distress through the means of technology, which in this case CBA used technology such as Instagram to conduct her cyberbullying. Further, the application of the statute did not violate the First Amendment protections of free speech. In Tinker v. Des Moines, the court established a need to balance students' First Amendment rights with their goals and needs of educators in the community.
Counsel, I wanted to ask you about whether the Tinker analysis is really appropriate here. I mean, to your opposing counsel's point, this is a criminal statute. So shouldn't we consider more traditional First Amendment principles rather than kind of the reasonablest test that's developed in Tinker for use for school rules, discipline, suspension, things of that nature?
Yes, Your Honor, but Tinker applies in this case because the students' First Amendment rights were being limited by the school, and Tinker upheld that they do not shed their school rights their rights to free speech in the schools. However, they allowed the schools the right to prescribe and control conduct in schools when there is an interference in school activity, which we see in this case, both in their attendance in classes and on the basketball team with games and practices.
Counsel, you addressed in your opening that the least restrictive means, test applies here. So was it the least restrictive means here to go through a criminal prosecution versus, say, suspending the student or doing something different to address the conduct?
Yes, Your Honor, because the legislature does not have the power to suspend students in schools. That would be an administrative power, so the legislative power that they used was the least restrictive means. Further, the school's purpose is to educate, and it should be and CBA's post directly disrupted the school's goal in educating students by affecting their attendance in classes, and multiple students were walking out of their classes because of the post. And further, in Mahanoy Area School District VBL, the court held that a school could not regulate a student's social media post that was made off campus. However, in this case today, CBA's post was made on campus and during one of her school classes, and therefore the school has the right to act in loco parentis to regulate her speech because of the disruption that it was causing within the school. So therefore, they were correct in applying that statute and did not violate her rights. So for the aforementioned reasons, this court should affirm the judgment of the lower court and find that Florida Statute Section 836.15 is constitutional and did not violate petitioner's rights to free speech. Thank you.
Thank you, counsel.